both by the plaintiff and the defense of trying to pound a square peg into a round hole to make something that doesn't quite fit to fit. The police power violation. My copies are so bad I can't read them. The November 20th citation, which is file number 242063. That is a violation of the recently adopted ordinance that the township adopted in July of 2024. Mr. Kuhlman told the defendant, we can't reach a resolution on this. I'm going to propose that we change the ordinance. And as Sherry Nowicki said, this document evolves. We had a case several years ago in another township where somebody wanted to put up a car crushing enterprise. They had a large parcel of property. It was near some wetlands. And the people were angry. In fact, the car crushing equipment got sold from somewhere else where the people are angry about having a car crusher. They're loud, very loud, noisy, dirty. But at the time they wanted to put it there, it wasn't prohibited. So they changed the ordinance to say you can't put up a car crusher here. And there was a big fight about it. And eventually it was not put there. But Ross used the example of a meth laboratory. Nobody wants a meth lab in their neighborhood. But at one time, there was no such thing as a meth lab. And the world changed and ordinances adapted to prohibit that sort of thing. So I do believe that ordinance was passed under the police power. And it was in effect at the time the citation was written. Mr. Mayor was told this is going to happen. They passed the ordinance. Officer Kuhlman sent him a letter and said, you need to move this stuff or we're going to cite you under the ordinance. So he decided not to do that, feeling he had the right to use the property in his neighborhood in the manner that he wished to. There may be some sort of neighborhood restriction of this. I don't know. I'm glad I don't live in a neighborhood that has an HOA or deed restrictions, but they're very prevalent. You almost can't buy a house anymore that doesn't have it in there. So they changed the ordinance to apply to you, and I think it fits. This is construction equipment that you've got parked in the middle of a very nice residential platted neighborhood. Now, Ms. Nowicki threw some shade at 7th Street, but you couldn't do this in 7th. You couldn't take an empty lot in Three Rivers and park all this stuff there. If it was in the city of Three Rivers or most other townships, to take a bunch of construction equipment and park it in a residential neighborhood. This would be prohibited almost everywhere. And you have a place to move it to. Granted, you do have a number of construction projects that you wish to do on your house and eventually on this lot. The time frame of that is measured not in months, but in years or decades. And the township elected officials don't want to wait years or decades. So I find that you are responsible for the enacted vehicle storage and repair ordinance. It was effective July 21st, 2024. Now, that wasn't enough. So in January, again, I can't hardly read my copies. They charge you with operating Mayer Brothers building from your residence without a permit. This is where we kind of get into pounding a square peg into a round hole. I don't care if you use Birchleaf Court as your mailing address, and if people remit payment to you, they send it to that address. Frankly, I don't care if a client comes over and signs a contract at your house. I don't care if you do quotes and estimates from a computer in your house and email them out. Mr. Truckee makes a point that it's sometimes hard to determine where the line is. Where does it become a home business and where doesn't it? And he came up with a number of, you can do this with any statute. You can try to find some absurd example that somehow wouldn't comply, like talking on your telephone to a client. That's not really what this is about. The language is a bit difficult. The ordinance defines home occupation as an occupation or profession customarily carried out by an occupant of a dwelling unit as a secondary use, which is clearly incidental to the use of the dwelling unit for residential purposes. And everything I just said was in the house. Here's where you get sideways with this ordinance, and is confined completely within the dwelling, subject to the following specific conditions. No home occupation shall be permitted to be established or expanded when the same is objectionable as determined by the Planning Commission due to noise, dust, smoke, or traffic congestions, reduction of the living environment, or other causes detrimental to the neighborhood in which it is located, which is quintessentially this. There shall be no equipment or machinery used in connection with a home occupation which is industrial in nature. I agree with you, Mr. Truckee. I don't know what that means. Home occupations are defined in 95.402A. There shall be no alteration of the residential character or function of the premises in connection wherewith. There shall be no equipment used in connection with home occupation which is industrial in nature. Then we go into the parking ordinance, which is 951401 C. Parking of motor vehicles in residential zones shall be limited to passenger vehicles, one camper style recreational vehicle per dwelling, not more than one commercial vehicle of the light delivery type, and this semi does not qualify as that. Not to exceed 3/4 of a ton and shall be permitted per dwelling unit. Parking of any other type of commercial vehicle or bus except those were parked on school property is prohibited in a residential zone. So I suppose if you could get a building permit and park everything in a pole barn that you built over there, although you're still going to have the same issue of driving this stuff in and out of that lot to go to job sites. And I don't think they're going to be satisfied. I'm not sure. I shouldn't get ahead of myself because it's probably not going to happen. So I made a finding that you're in violation of the police power ordinance as cited in 241 or 242069 ON. They changed the ordinance, even if they arguably changed the ordinance to apply just to you. And they aren't applying it to anybody else in the township that may be violating this statute. That doesn't mean that you are not. So what was previously not unlawful became unlawful with the authorization of this statute. And they gave you time to remedy it. You chose not to, and you chose this path of most resistance. Which frankly is your right. If you're willing to bear the anguish and the cost of this, more power to you. You don't have to immediately bend over and take it, but it would have been a lot easier. Take a spanking rather than go to this. Anyway, I find you responsible for a $100 fine and $100 cost. And the 251088, operating a home business. This is a bit of, as I said, a square peg in a round hole. They already had the tool that they needed to get what they were asking for. I find a $1 fine and a $1 cost in 251088. Regarding the bill of costs for the May 28th incident, defendant is ordered to pay everything that the plaintiff requested. Here's where the wrinkle is. In most cases, the district court does not have equitable jurisdiction, meaning you can order somebody to do something or else. They do in zoning matters. You're going to either move this stuff or they're going to move it and give you a bill. We'll talk about that in a minute. The gentleman this morning that you, at the very start of this, had a series of horrible zoning violations on his property. He had people living in campers and generators and tents, and I ordered him to not do it. I ordered him not live there. They had some children living in some sort of a lean-to with a gas heater or something, and they burned up and were killed on his property. And then he continued to violate, and I ordered that he not do that anymore. And then in violation of my order, he moved back in there with generators and electrical extension cords and a recipe for a fire. I have the authority to find him in criminal contempt to put him in jail. We're going to have a hearing about that later. It happens very rarely, but that's about as bad as it gets. But you're going to have to either move this or they're going to do it for you.
Is there going to be a clear finding on which specific articles need to be removed?
Well, that's the devil is in the details. The only one that doesn't, I think he has an argument on, is the scissor lift. But I wouldn't want to leave a scissor lift out there by itself in the weather. You could have a plausible use for the scissor lift to put your flag up and down or work on your house. But the semi can't be there. The dump trailers can't be there. The man lift, the Bobcat, can't be there. So in his argument, Cunningham told me what he wanted. I've ordered the fines, $100, $100, $1, and $1. This isn't about money. This is going to be about code compliance with a compliance order. I did order the cost to the township for the adjourned hearing. This is called a compliance order. They're going to comply it or compile it. You have 21 days from today to be in compliance, 21 days from the day I signed the order. And we didn't pull that out of a hat. You also have 21 days to appeal this. If you wish to appeal it to circuit court and have Judge Stutzman or another judge review this and stay it, you can do that. You have to file it within 21 days. So absent any appeal within 21 days, this property shall be removed. And the order shall be continuing that it remain in compliance with both of these zoning regulations. The more direct charge was the police power charge. Parking and home business are kind of tangential matter. And as I said, I've ordered things that people did not like. I've ordered that a church be torn down. I've ordered that somebody tear down a $100,000 addition to their house because part of it was in the road right of way. I've ordered that property be scraped clean. A particular trailer park was in deplorable condition. And 50 trailers, I don't know, were removed from there. That's all hard. This is relatively easy. You're a construction guy, you got trucks, you got trailers, you got a place to put it. Take it there and put it there. If you need to use it to come back to your house, you use your telelift to put bricks up on the veneer, I think you're entitled to do that. But to leave it there stored indefinitely for the next 5 or 10 years is just going to continue to engender more hard feeling. The lot itself is quite nice. This property is not zoned agricultural. I had a man in another township, there's a long story, but he was at odds with another township for years, and they wanted him to remove some things. He had cars stored there. It was zoned agricultural. So I put up a fence and brought in about 10 pigs and said, how do you like that? We don't need that. You just need to move this stuff to your Fabius Township property. You need to work on the stuff you need to work on and get on with your business. And eventually you'll make the improvements on your house. And at some point, if you're going to build a pole barn and they give you permission, more power to you. Mr. Cunningham, I'd like you to do the order.
Sounds good, Your Honor.
So I don't know, we'll do it under the 7-day rule. We'll probably have, Mr. Truckee may have some objections to it. Once you present the order, maybe we'll have a brief hearing regarding the entry of it unless they object. Mr. Mayor, what it means is he's going to do the order based on what he said and what I argued. If you contend and your lawyer contends that, hey, the judge didn't say that. The judge didn't say I had to do this, so I'm not agreeing to the entry of this order. I'll have a hearing to determine that. If the order set complies with what I said here, you don't need to do anything, you just enter after 7 days. So essentially, you've got about 28 days to get your stuff off of there before any enforcement could take place. If you appeal it, Judge Stutzman could stay the operation of that order, and everybody could spend a lot more time, effort, and money fighting about it. That could take years. I'd like to bring some finality to this for everybody in the township, everybody who's living with this, and there's a relatively easy solution. Just move it. All right, is there anything else we should place on the record?
Nothing from us, Your Honor.
All right, I'll await your order. If it's not objected to, I'll sign it. If it is objected to, I'll set a hearing. All right, thank you. We'll be in recess.